initiate investigations all the time in the absence of complaints where they have a reason to suspect that there could be potential issues of legal compliance. And look, it could be the case, based on our investigation, when we look at documents, when we look at information, that ultimately will determine that First Choice isn't liable for any violation of the law.
Well, that just seemed to be a burdensome way to find out whether someone has a confusing website. But you said earlier that you did not agree with their characterization of why they were being put to this. And it would seem that the obvious way to refute that was to say we had 100 complaints. But you say you have no complaints, but rather you looked at the website and their materials and you think it could have been misleading. So why is your characterization any better than theirs?
So, Your Honor, I'd point you to the Turner Declaration, which is at pages 400 to 401 of the Joint Appendix, which lays out the predicate for the state's investigation of First Choice. And we had concerns in 4 buckets. We had concerns about potentially misleading donors. We had concerns about the unlicensed practice of medicine. We had concerns about patient privacy practices. And we had concerns about potentially misleading or untrue medical statements. So I think we had a more than ample basis to initiate this investigation.
But you had no complaints.
We had no complaints, but I think that, Your Honor, that goes at most to the merits. That doesn't go to the standing analysis.